welcome to the panel on Beyond Resistance to the War on Higher Education. And so I'm going to give very brief introductions to our panelists. Since we have more extended biographies in the program, I'm going to leave it to you to kind of read them. And we're going to go in the order that we're sitting. So on my far right is Professor Mario Barnes. He is a Chancellor's Professor of Law at the UC Irvine School of Law, where he returned in spring 2022 after serving as the Dean and Professor of Law at the University of Washington School of Law from 2018 to 2021. Professor Barnes is a nationally recognized scholar for his research on the legal and social implications of race and gender, primarily in the areas of employment, education, criminal, and military law. Our second speaker will be Professor Stephen Bender. Steve is an Associate Dean for Planning and Strategic Initiatives and Professor of Law at Seattle University Law School. He is a leader in critical theory and an expert in real estate law. Among his honors are the C. Clyde Ferguson Jr. Award from the AALS Minority Group Section and SALT's Great Teacher Award. He joined Seattle University from the University of Oregon in 2011, where he received the Maine University's Research Innovation Award and co-created the school's Ethnic Studies Department. At Seattle University, he co-created the Critical Justice Initiative, which is relatively new, with Angela Harris. He's a longtime leader within Black Crit, established the AALS Critical Theory section, and co-created the Law and Societies Association of Displaced Peoples.
CRN.
CRN, right. Thank you.
This is Mr. Law and Society right now.
Yes.
Yeah.
Our third speaker will be Amira Dale. Dale? Okay. And Amira is a JD PhD and is the Honorable Vanu Spencer Professor of Law at Southwestern Law School. She's also the director of the Law School Survey of Student Engagement and affiliated faculty at the American Bar Foundation, where she was recently the Newcomb Fellows Research Chair in Diversity and Law. Her research merges jurisprudence with empirical methods to interrogate hierarchies in legal education. Professor Dale's book, An Equal Profession, Race and Gender in Legal Academy, Stanford Press publication, examines the intersection of race and gender with law faculty experiences. And then I will be your last speaker. My name is Athena Mutua. I'm a professor of law and the Floyd H. and Hilda L. Hurst Faculty Scholar at the University at Buffalo School of Law, and I specialize in the area of civil rights and critical legal analysis of race, class, and gender hierarchies. And so I'm going to turn the floor. Welcome. Thank you for being here. And I appreciate Maddie, who is helping us today, and all of those who organized this terrific conference. And so I want to pause now and turn the floor over to Mario.
So thank you very much, Athena. Such a privilege and a pleasure to share space with this august group and to be a part of this amazing celebration, especially in a time where I think we need things that help uplift our spirits and recommit us to our vision and values. And so I'm going to spend my time talking about an ongoing project I've started working on, which is tentatively titled Strange Bedfellows, Government Attacks on DEI CRT, and the Death of the Intent Standard, with a question mark. So, as Steve mentioned, I am the current, as of June, the current president of the Law and Society Association, the first African-American male president in the history of the association. But let it be noted that I am following in the footsteps of amazing UCLA CRS people, because the first person of color and the first Latina president was Laura Gomez. And Laura Gomez is the person principally responsible for keeping me in LSS and LSA and helping to elevate my presence within the organization to the point where I was capable of being elected president. It was a funny story. When she was president, she oversaw a slate that nominated me for treasurer, and I went to her and I complained, I will not run for treasurer because the other person is a person of color, and I refuse to run against a person of color. And she said, really? What happens if you win? I'm like, well, a person of color wins. Like, what happens if you lose? Person of color. Oh, okay. I'm sorry. So I missed the plan, Laura. But she did a lot in her time to orchestrate improving the diversity of law society, including one of the things that she did on her watch becomes the source. One of the sources of this talk is during her time they worked on a proposal for a grant to NSF, which sought to partner Law and Society, the American Bar Foundation, and NSF in supporting postdocs whom the goal of was to improve the diversity of social legal scholars and scholarships by placing postdocs at the American Bar Foundation, where the funding primarily came from NSF. The training site was the ABF, and then to provide mentorship through LSA and by giving them spaces in the conference and committee assignments and other things. And so this worked seamlessly for 5 years until this past spring, where LSA, ABF, and received a letter from the NSF announcing with no warning that the postdoc would be defunded. Of course, that was terrible, given that there was somebody who was in the postdoc who were counting on the funding, and we had just offered a position to the next postdoc, but they were immediately withdrawing funds, and the explanation they gave was that the postdoc was no longer consistent with administrative priorities. Of course, as the lawyer, my point was there is nothing in our agreement that suggests that that's a basis to cancel the funding, but it became pretty clear in short order that anything where the administration had previously, or at least where funding sources had previously dedicated funds to things that seemed to support diversity, equity, inclusion, would be defunded. And then they went 2 steps further. The administration more broadly, even for projects that weren't explicitly committed to diversity, equity, and inclusion, they started threatening to pull funding if researchers didn't disavow DEI, even though it wasn't the goal or source of their project. And then they did something beyond that, which is even if people were willing to say, oh, ours is not a DEI project, and you would sign it, if they had a suspicion that there would be some benefit that adhered to the interest of what they thought were the goals of DEI, you would come out with some findings that would be alleged to support what they thought were the woke politics of DEI, they would defund you. Now, this is all deeply problematic for numerous reasons that have to do with First Amendment, freedoms, as well as what are the conditions under which the government can defund you after entering into agreements to fund you where the defunding happens, not subject to one of the agreements or terms in the agreement which would allow it to take place. And so there have been many suits. I encouraged us at the ABF and LSA to join these suits. But what it started me to thinking about is this claim that the administration had about DEI, even though in our case it was an explicit commitment, that they were going after people who didn't have explicit commitments and for where there was no proof other than the administration's determination that this was the type of work that they would be doing or benefiting. And then they became explicit with it in a set of executive orders where the president starts using phrases that DEI programs are smuggling in racial stereotypes and explicit race consciousness into everyday training programs and discipline. But in a number of, there's now 4 or 5 executive orders and the Dear Colleague letters, the thing that struck me was they were no longer just talking about programs that were explicitly DEI focused. And in the Dear Colleague letter in particular, they said, our mandate from SFFA versus Harvard is to root out all racial discrimination in institutions of higher education, which included to them institutions that relied on non-racial information as a proxy for race and making decisions based on that information. They also highlighted that there are programs that discriminate in what they called less direct but equally insidious ways. In other words, there was not explicit proof, but where they certainly believed the benefits were for DEI purposes. And the language, they ultimately say that the department will no longer tolerate either the overt or covert racial discrimination that has become widespread in the nation's educational institutions. And so one of my problems with this is I've been teaching constitutional law for 20 years. And so one of the things you know if you teach constitutional law is, at least when we talk about equal protection claims under the Constitution, some proof that there's a disparate racial impact alone is insufficient for you to establish a violation under the Equal Protection Clause, because you must, in fact, have proof of discriminatory intent, right? There must be something there that suggests that the government purpose was to create this outcome, including language in some of the cases that's so strong that you have to prove that it was the actual intent, not that the government is going forward with in spite of the discriminatory impact. And so there was, for a long time, a split between the constitutional claim and the statutory claim under Title VII, where under Title VII, you could actually have a disparate impact claim. But certainly since the case of Ricci versus Stefano, which is a Supreme Court case involving New Haven firefighters, what happened in that case was New Haven used a test where the results of it would have resulted in the promotion of a group of firefighters would have been all white and one Latinx firefighter. No African Americans would have been promoted. Based on the result of the test, New Haven wouldn't certify it, and essentially they were going to start over. New Haven gets sued by the folks who would have been successful under the test, and what happens is the Supreme Court says in that case that New Haven, in attempting to avoid a disparate impact claim from the African American firefighters who didn't score well on the test, has created a discriminatory intent, has engaged in discriminatory intent against the successful applicants. And so it creates this, the standard they use is, unless the government has a very strong basis in evidence to determine they would be subject to disparate impact liability, they're not allowed to do anything which would harm the interest of those who would have the disparate intent claims. And one of the things that's important in this case is Justice Scalia had been for a long time trying to undermine the disparate impact claim, and what he says in his concurrence here is disparate impact sometimes may be evidence of discriminatory intent, but many times it's not. And essentially he claims that we need to get rid of generally the disparate impact claim because it itself is discriminatory or racist. And so I've been living in some ways with the split between the constitutional approach and the statutory approach, and the sort of winnowing of the statutory approach, or the importance of disparate impact for some time. But the thing that struck me in all of this language in the executive orders and in the Dear Colleague letter, lots of what the administration claims is their proof that DEI and similar programs are violating discriminatory practice and policy is merely what they believe to be impact evidence without any proof of motivation or intent. And so my sense was, how is it possible that for years progressive scholars have been fighting against this approach, which we refer to as the intent standard in Equal Protection Clause jurisprudence? Have we been fighting against having to find the very discriminator behind some government action or policy in order to be able to have a successful claim? But the administration now can come forward and simply say, we are going to move with enforcement practices based on race-neutral policies which they believe are beneficial, places where they believe there is covert benefits or discrimination, even though they have no proof of it. And my sense was, beyond the sort of First Amendment problems with attacking commitments to DEI, do we have a problem with the administration's approach upsetting the constitutional jurisprudence that exists in the space? Now, one of the things I have the problem with, normally what we are talking about is individuals claiming that they are being discriminated against using impact evidence, then at least still for a little while in the Title VII context, trying to move forward with a test that would allow them to make a claim. In the constitutional context, impact alone wouldn't help them. But normally what you have is an individual coming forward and claiming to be subject to a process which is creating the impact and then trying to establish the basis for a successful claim. The problem is, in this context, we don't have individuals who are saying they're being subject to a circumstance where impact is the problem and where they can't prove intent. What you have is the government operating in the space of moving to enforce a standard that is not the legal standard that the court observes, were this to come before the court. And the trick or problem is, well, is the executive enforcement at all someplace where this could apply, when really what you're talking about is typically equal protection claims or employment claims, individuals to the court, and the government's action needing to have some proof of intent. In other words, could this be a case where it's do as I say, not as I do? So if I want to sue the government, I got to have proof of intent. If they want to end DEI and other programs, they don't. They can just have the suspicion that that's your goal. And so I've been trying to put together what is the sort of legal response that gives us a way to think about capture of either the government having to then be held accountable to the intent standard that we live with in our own anti-discrimination law, or changing anti-discrimination law so everybody gets the benefit of no longer having to prove discriminatory intent when we're alleging impact. And so the place I have landed thus far actually turns out to be a corollary from Section 5 of the 14th Amendment, at least in the court's approach to equal protection jurisprudence. So what happens in the 14th Amendment context is Congress has the power under Section 5 of the 14th Amendment to enforce the language of the 14th Amendment. The problem has been historically that any time Congress moves to use that power and does it in broad, significant ways that misalign with the court's own more limited jurisprudence on equal protection, the court curbs their power. In other words, anytime Congress acts to broaden the protection using their Section 5 power, that would be inconsistent with the more limited ways in which the court would apply equal protection doctrine in their jurisprudence, what you find is the court striking down the power of Congress to exercise their Section 5 power. And so the real question is, rather than putting all of our eggs into the basket of freedom of speech and that the administration is targeting the content of the messages, is there a way in which we can think of stylizing claims which suggests to courts that one of the problems that is going on in this current, these attacks on DEI, which are not now just limited to defunding, right? Now there are the letters to the firms and the universities saying we are attempting to enforce civil rights law, our own interpretation of SFFA versus Harvard, which is that these programs are in fact violations of the law. Is there a way in which you can stylize a claim that suggests the executive and the way in which they are carrying out these attacks on DEI is actually moving in a way that is inconsistent with the understanding of how anti-discrimination law works, which in order for them to be able to enforce this policy, they should be limited by the court's own understanding of when discrimination exists, which means if you want to use impact evidence, you actually have to have proof of intent. So my project is basically putting together on the one side all of the cases under the Constitution and under Title VII, which talk about the intent standard, and then on the backside, looking at Congress, how they've limited the Section 5 of the 14th Amendment power to force Congress to be consistent with the court's own understanding of anti-discrimination law. Can we force the executive to be equally curbed? Now, just so you know, none of this is great, right? Because the truth is, we've been attacking and wanting to get rid of the intent standard forever, not particularly successfully. I'm not sure we want a world where the answer is, well, we'll take it away on the plaintiff side as long as the government doesn't have to be bound by it either. Because of the differential in power and the effect of that, it could be horrible. Yes, more claimants will move forward on impact claims, but the government would be free to engage in enforcement without having to prove that there was any discriminatory motivation. So I have to work through what is the goal you are hoping for with this. But right now it is pretty clear they basically are unwilling to accept any traditional limits from anti-discrimination law on how they are moving to suss out and then curb what they are claiming are the problems with DEI. So I will stop there because I'm at my time, but I'm happy to say more about it.
So I'll pick up on some similar themes. I'm going to talk about the ABA, accreditation, affirmative action, diversity, Bondi. I teach my students the critical history of the ABA in the early 1900s about its campaign against night law schools, against black law schools, that really got us into the accreditation and placed hurdles that we have today. And a number of us benefit from that. We've got the need to go to have an undergraduate education, take a standardized admission test, attend an expensive law school with full-time faculty mandated, with libraries and infrastructure, with a grueling bar exam when you come out, and that's your entry into the profession. And it was intended to and had the impact to exclude on the basis of a number of identity groups, poverty, class, immigrant, black, and those who were perceived as racialized from Southern and Eastern Europe on the basis of religion too, Jewish, and a number of other groups who were impacted by the cost and class exclusions. And as a result, we practice within one of the least diverse, sometimes said the least diverse profession. Judged by any standard, a 2020 ABA study, 5% of the legal profession black, 5% Latinx, 2% Asian, less than 1% Native. And those percentages are despite the advent for a few decades of affirmative action, which remedially returned some of, but not all of the damage and the hurdles that were in place by the ABA. So you've got the ABA with Standard 206 coming into the picture saying, all right, we're going to mandate, not necessarily mandate diversity in admissions, because it's been pointed out that the ABA Standard 206 doesn't directly mention admissions. It just says that you've got to have a commitment to diversity and inclusion and provide full opportunities, and a commitment to having a student body that's diverse with respect to gender, race, and ethnicity, as well as a faculty and staff that is diverse on those grounds. Hofstra got dinged a couple of years ago on the basis in the application of this standard of a non-diverse faculty, 5 out of 47 people of color in Oregon with regard to adjunct faculty. But then came along SFFA and the attack on affirmative action and the AG campaign from 21 red states that sent a letter, and then Bondi that weighed in and waded into this battle of threats and interpretations of SFFA, leading to the ABA suspending it until next summer, suspending that standard 206. So the ABA is under attack, and the ABA is an empowered federal accreditor for purposes of financial aid. Of course, there's also state accreditors, usually the Supreme Court, that decides who's eligible to sit for the bar and practice law, and connects it back to the ABA, saying you need to have graduated in most states from an ABA accredited school, though not all, like California and Washington. So where does that leave the ABA? And should the ABA capitulate, or should it really double down on that standard? And remembering what Kim Crenshaw said last night about sort of and anticipating what might happen to the ABA if it doubles down, and probably will instead of might happen, is her wisdom that the fight is now, or they're really fighting to save themselves and not fighting for us, is what she said. And so in terms of doubling down, I would argue we do that even though we know from critical theory that diversity and diversity initiatives, like rights, are important but incomplete. And in the case of diversity, like Gerald Torres wrote about in his article Synecdoche in the Harvard Latino Law Review and Alacrity Symposium with regard to tokenism and capture, that we know from a critical perspective that diversity is incomplete. But Kim Crenshaw, coming back to give a talk right after the LA fires, I remember her saying that they're coming for all of it. Not just one thing, but all of it, everything that was done from the civil rights era on. And so you have to fight for basically everything to save something. So what's going to happen to the ABA? We know it'll probably be replaced by some federal accreditor, some Federalist Society-based thing. And Bondi essentially said this, put a gun to the ABA and said, choose between your diversity ideals, 206, or your ability to survive, save yourself. Whatever happens to 206 and whatever happens to the ABA, law schools could still continue to perform DEI and affirmative action-based measures, I guess, until that replacement accreditor says you can't do this as a matter of our new standards, say that you can't do these certain things. Or Bondi stays true to her word and goes after the individual schools who are, for so-called reverse discrimination. If that's the case, then we know some of the arguments that would be made. Religious schools like mine that I've said, make sure it's in your mission, because we're going to have to hold up the mission and say, and it needs to be there on a stone tablet, what our mission is. But then beyond that, really the legal profession, showing there's some unique need within the legal profession, and that's where you hearken back to the Michigan cases and what Michigan wasn't willing to do, but Margaret Montoya and some students were, which is let's intervene and let's show the dirty laundry of the history of the school, and let's have it decided maybe not on a more tenuous interest convergence diversity rationale, but on a repair and remedial rationale. And couldn't we do that with regard to the ABA if we focused on the ABA's role in exclusion that got us one of the least diverse professions? And couldn't we then challenge the ABA in the ways that Michigan was challenged and failed to say, ABA, will you acknowledge your role and your dirty laundry? ABA, will you work with us to say, we get this? Is that in part what was behind 206? You could do that. You could have in place that without taking responsibility, but you were responsible, and so hang with us and take responsibility for this dirty laundry. And so you also look at the states and the states as gatekeepers to the profession, because if the ABA went away, or there was some replacement, the state Supreme Courts could say, you need to graduate from a school that has diversity standards, and they could also impose what the ABA did in Standard 303C, which was a commitment to anti-racism education. That could all be done either at the individual school level or on the state accreditation side. But then Pam Bondi said, it's unclear how state laws can lawfully continue to require prospective lawyers to attend ABA-accredited law schools if the council continues to abuse its privilege in this way, which was not repealing 206, and perhaps she hadn't focused on 303C, or she would. And then the Department of Justice stands ready to take every action necessary to prevent further abuse. So here are some takeaways. I say we double down on diversity with the ABA. That would then mean, would the states start would the Fed start attacking state-based accreditation for purposes of who's eligible to take the bar, or through alternative pathways like Washington. And we've seen that Trump has no hesitancy to attack blue cities, but then blue states are a bigger matter. Pipeline programs. I oversee a number of pipeline programs that are framed in terms of post-SFFA, for example, in Central Washington, geographic diversity, which necessarily delivers racial diversity because of the agricultural economy of that area and other reasons. We could also attack other sites of historical exclusion. If we're talking about admission tests, if we're talking about bar exams, if we're talking about the cost of legal education and higher education as a gateway to legal education, those are things that were in place for lawyers, by the ABA, that we could start reconsidering, even though that could make us uncomfortable in our comfortable roles. So finally, I would say we should also look internally, because we have most law schools surviving and thriving to this day because of the dirty work the ABA did decades ago to quash other cheaper pathways to practice, like apprenticeship and night school. So what can we do different as law schools with that legacy to produce better lawyers than those alternative pathways would have provided? And we need to really see law school as an opportunity to do better, to really, with regard to 303, see the anti-racism, anti-bias, cross-cultural understanding standard. We really need to address that, because it recognized the racism and bias that pervade both law and the legal profession. So we need to start thinking about, like, how do we use the venue of law school to help change that? Or why are we here if we don't? And CRT is one vital contribution that the Academy has made toward that fight. But what more is needed? That's it.
Thank you for bringing up the Michigan cases, Steve. I was one of those student interveners 2.5 decades ago. I appreciate the reminder, really, now looking back, that litigators can really learn so much from students, which is really what I took from your comment there, including the students, those of you who are here today. I really think you can inspire us to be more creative, maybe, to think outside the box a bit, even in terms of litigation strategies. So thank you for that suggestion and reminder. Good afternoon. I'm here to talk with you about resisting overcompliance. I'm setting my timer so that I can make sure that I follow all the rules. Since early 2025, the federal government has sought to eliminate diversity, equity, and inclusion across virtually all realms of education. And they're doing so extra legally. While university officials focus on whether to comply with political directives, the more nuanced question is, at what level should they comply, if at all? For every decision, of course, leaders will have to consider a responsive spectrum ranging from resistance to overcompliance, with a balance of potential costs and benefits that accompany each level. So my remarks today and the essay on which they're based assess compliance with federal anti-DEI directives by introducing the concept of resisting overcompliance as a guiding framework. They actually build quite seamlessly on the remarks that you've heard from my co-panelists already. You may know of historian Tim Snyder. I saw him speak at the Skirball Center last night. He has written a few famous books right now, which has come back into favor, as one called On Tyranny, that you may know of. And in that book, the first lesson he gives us to warn against fascism is not to obey in advance. And so similarly, my framework urges us to do only what is absolutely required, no more, perhaps a little bit less. So first we have to determine what the law requires, then we have to consider whether to comply, even a little, with relevant directives or to resist outright. And third, if we do choose to comply at all, we have to determine what level of compliance is appropriate. So the resisting over compliance framework describes the choice to comply rather than resist, but only to the extent that's minimally required by existing law, rather than to kind of feed our impulse to do so excessively, in part to mitigate our own risk. The framework also provides guidance on actions that remain permissible, even within current legal and political uncertainties. So I do want to say at the outset that I do unapologetically take sides. I'm on the side of defending democracy, promoting academic freedom, protecting free speech. My framework rejects both the extra-legal content and the extra-legal processes that characterize current government directives. Mario spoke about some of this as well. Substantively, these mandates are extra-legal because they demand more than what is legally required. Procedurally, they're extra-legal because they thwart established legal processes to issue threats that circumvent established method. And we can put this in context. I built my framework in response to education-related mandates issued by the federal government earlier this year. Yesterday, Amanda Shaner, if you were in her concurrent session, referred to this as the first phase, with recent invitations to join the federal compact as the second phase. So in this first phase, on February 14th of this year, the U.S. Department of Education issued a Dear Colleague letter warning pre-K through post-baccalaureate schools that they risked losing federal funding if they did not immediately eliminate all race-based, that's their term, programs, including DEI initiatives. Crucially, the Dear Colleague letter draws authority from Students from Fair Admission versus Harvard, and it erroneously asserts that the opinion empowers their directives. So SFFA did upend affirmative action in the university context, specifically at Harvard University, but extended to others, concluding that educational diversity was too amorphous to be a compelling state interest, and their program was not sufficiently narrowly tailored to withstand strict scrutiny. And this did lead to a decline in diversity in higher education nationwide. But SFFA does not impose any sort of mandate or prohibition on programming related to diversity, equity, inclusion, or any related concepts that the Dear Colleague letter claims that it prescribed. So it is substantively extra-legal. It's also procedurally extra-legal. As the California Department of Education has noted, a Dear Colleague letter is not law and cannot by itself be an enforcement mechanism. In fact, the Dear Colleague letter itself has a little note that says that too. At most, what it can do is assert a department's current interpretation of existing law. It can't promulgate new requirements. So this Dear Colleague letter embodies, in my view, a blatant attempt by the federal government to demand adherence to its own vision of anti-DEI futures by pretending broad restrictions are compulsory, although in fact they exceed any legal requirements. The compliance dilemma is amplified, of course, by the high stakes of potential loss of federal funding that's threatened in the letter. Nevertheless, any demands in the letter that go beyond the scope of existing settled law legally could be ignored. There's only been 2 federal district courts that have weighed in on the matter, and they have said the same. One issued a preliminary injunction noting that the Dear Colleague letter improperly attempts to impose new obligations on educational institutions, though really all it can do is interpret existing law. The other court similarly rejected the notion that the letter merely restates existing law, even quoting some prior guidance that SFFA does not prevent schools from continuing to seek admissions and graduate diversity, even through race-neutral efforts to promote diversity and increase opportunity, ultimately ruling against the government on summary judgment. So how should administrators respond? When faced with this complex decision about resisting or complying, administrators should not blindly follow demands. Compliance does not mean simply yielding to power without agency. Administrators should wield their power to determine both whether and how much compliance is appropriate. In determining their response to these new laws or regulations or directives, administrators and university leaders and others should adhere to the resisting overcompliance framework by asking a few questions. So first, what does the law require at its minimum? Second, given competing priorities, should the institution resist or comply? Those are pretty settled, I think, in terms of understanding what to do, how to make a decision about where to go. But don't stop there. We can also ask, if complying, what would demonstrate minimal compliance? If complying, how much overcompliance, if any, should the institution demonstrate? And if complying, which permissible actions should the institution continue? So the first step is to determine what the law requires. According to textual analysis of the Dear Colleague letter, as well as determinations from these two district courts that I've referenced already, the letter improperly exceeds the legal dictates of SFFA. It doesn't actually prohibit things like population-specific graduation ceremonies, housing, or campus gathering spaces, all initiatives that were singled out in the Dear Colleague letter. So succinctly, the law requires compliance with SFFA, nothing more. The second step requires universities to determine whether to resist entirely or to comply even minimally with the Dear Colleague letter. If complying, administrators have to then think about how much to comply. So each institution, of course, has its own constituents and priorities that work into this analysis. But we already know that the Dear Colleague letter cannot mandate obligations beyond the scope of existing law. Minimal compliance would require just that institutions adhere to the legal requirements set forth in SFFA. Most institutions, even those that disliked the ruling once SFFA came out, immediately did comply with it because it signaled Supreme Court interpretation of constitutional law squarely within their authority. Put differently, universities fully complied because the opinion was neither substantively nor procedurally extra-legal, although the Dear Colleague letter is both. So when leaders ask what would demonstrate minimal compliance with the Dear Colleague letter, the answer again is adherence to SFFA. All right, once we decide, right, whether to comply or resist entirely, then we have to ask what else to do. How much overcompliance, if any, should the institution demonstrate? Although doing more would exceed the scope of what the Supreme Court determined is legally required, institutions can choose to slightly overcomply without much excessive risk. So they could decide to eliminate certain DEI programs but continue to support others, things like graduation celebrations for students wearing cultural or ethnic garb, host panels of Native American environmental rights activists, or encourage gatherings of students of color looking for a safe space on campus. None of these are specifically prohibited by law. The last question is, if complying, which permissible actions should the institution continue? So I want to stress here that despite ongoing attacks on DEI, there are a number of policies and programs that remain unassailable regardless of the level of compliance that institutions choose for themselves. Among these, I would encourage schools to specifically focus on two goals: promoting belonging and enhancing well-being. So I'm going to speak for just a moment on these two to end my remarks. Belonging refers to the extent to which people feel connected to their community. So I often, in giving presentations at law schools and other settings, I talk about student belonging by saying that it's the glue that connects students to campus. And when we think about a campus, it's not just, an amorphous concept. It's really their classmates, faculty members, staff members, other spaces, other people at the institution. I went for a run here on campus today, and I was a PhD student here I started over 20 years ago, and it's lovely to be back in your space when you feel like it really is your space, to see things that are the same, to recognize what's changed. It's something that makes you feel at home. So schools can prioritize belonging without singling out any particular race or gender or sexual orientation, really any identity characteristic. And at the same time, we know from empirical research that marginalized students may nevertheless have the most to gain from opportunities that we invest in to improve belonging for all students. A strong sense of belonging leads to better academic outcomes, like grades, better professional outcomes, like jobs, better personal outcomes, including lower levels of depression, anxiety, and loneliness. Our forthcoming, literally next week, I think, annual report for the Law School Survey of Student Engagement focuses on disability in law school, and we reveal in that report that 1 in 5 students has a disability, and the majority of those who self-identify as having a disability or other condition that interferes with their daily functions, more than half of them have invisible disabilities, often mental health disabilities, including anxiety and depression. So this is something that could work to support students from all backgrounds, and particularly those students who may be struggling after SFFA may recognize that there aren't as many students from their backgrounds on their campuses now. By promoting belonging initiatives for everyone, we can still help those students who have lost other DEI-specific programs. So, for instance, another forthcoming piece of mine reveals how staff, administrators, faculty, even peers can be what we call cultural navigators. And these are people who help especially new students through the professional socialization process. So folks on campus who can help students adjust to the norms and expectations of campus life that may be very different from their own cultural backgrounds. Similarly, wellness programs, whether we're talking about meditation or yoga, journaling, nutrition education, mindfulness, physical exercise, anything you can think of with regard to wellness, they don't have to be targeted to any one particular identity group. And yet they would still help students of color as well as others targeted by anti-DEI initiatives. Now, I don't believe we should be using well-being or belonging as proxies for DEI. They present their own wonderful opportunities to enhance the educational experience and support students from all backgrounds, including those who may feel a bit lost after the loss of these DEI initiatives. Given the level of political uncertainty involving the future of DEI in higher education, decision makers should use this framework of resisting overcompliance to determine whether and how much to comply with various directives. The framework also helps clarify what remains permissible despite these ongoing anti-DEI attacks. Even when legality is clear, of course, institutions and administrators may be attacked on purely baseless grounds. We've seen that repeatedly this year. But we all know that when faced with a bully, resistance is key, particularly for those who support democracy, free speech, and academic freedom. Even those who choose some level of acquiescence can still resist overcompliance. And I urge us to think through that in our daily interactions and daily opportunities for resistance as well. Thank you.
Okay, so can you hear me? A little bit closer. Is that better? Okay. So you've heard a little bit about kind of where we are and what we can do. So this is in some ways, we're the fight panel. And now, we're being very nice about it, but we're the fight panel. And so now I want to give you a chance to also participate in resistance and beyond. And so I'm going to switch the focus a little bit in this talk to give you this opportunity while shamelessly asking you to join the Critical Legal Collective. And that's what this talk is about. So I want to do 3 things. First, I want to provide you some background of the events and the intellectual foundations that inform the formation of the Critical Legal Collective, which I will refer to as the CLC. And I will do so beginning with gratitude for and about this conference and this space. And I want to make some observations about CRS. I then want to describe what CLC is doing and has done. It's relatively young. It's about 3-4 years old. And our current campaigns, which I would encourage you to participate in. And then I want you, and I hope there's time for this, I think there will be, to ask you what you think formations like and institutions like CLC should be doing. What should your schools be doing? What should the ABA be doing? What should other institutions like CLC and others, what should we be doing in this moment? Okay, and I will close with that. So first, I want to thank all of those who participated in organizing this terrific conference. And I want to thank all of those who participated in the institutionalization of CRS, and I want to focus on that. And give gratitude to all of those who are working to maintain it in this moment. I got the sense of the program when I was out here some years ago, but it has grown to be so much more and has done such terrific work. And I've been impressed over the last couple of days to see how the CRS has been kind of conceptualized. The institutionalization of CRS has been conceptualized as an act of praxis, where critical race theory and related scholarship is taught and further developed, the way in which it is a site for programs, actions, and activities that are both informed by the scholarship, but also inform the scholarship and has helped to develop it. And I've been particularly impressed and enjoyed a lot of the discussions about using the human rights discourse and the human rights movement and its relationship to race, the discussions that link CRT and TWAIL, which is Third World Approaches to International Law, among other things. And I'm gonna talk about that a bit, but I'm really here focused on the institutionalization of CRS and others. And so as I was kind of listening, and so I had to rewrite my talk last night. As I was listening to all of the discussions yesterday, it put me in the mind of other formations where we have tried to institutionalize. We've engaged in the praxis of trying to implement CRT and related of scholarship. And so I thought very early on, I thought of the creation of the Kenyan Human Rights Commission. And I guess that's why I was thinking so much when I heard the discussions around TWAIL. So in 1992, Mikhail Mutua sat down in our bedroom and drafted the charter for the Kenyan Human Rights Commission, the KHRC, which I believe is the largest human rights organization in East Africa and maybe the largest human rights organization in Africa. And it was first incorporated in DC because it couldn't be registered in Kenya at the time. Now, the KHRC, of course, was the result of a lot of varied factors, but part of those factors included the insights that were generated through TWAIL. That you had Tony Angie, Mikhail Mutua, Chimney, Vasuki Nasaya, and others pulled together this associational form of 12. And so the idea of creating this thing emerged in part out of a group of people who were in a particular place in the early 90s. And from my very limited perspective, of course, the KHRC owes its formation, of course, to the particular events on the ground in Kenya, which was in a struggle for multi-party democracy. And that was widespread, right? So we had, not so much in Latin America, but across Africa, this kind of burst of energy around democracy and multi-partyism. And so the KHRC gets established in this particular moment. But as someone at this conference said yesterday, right, that we're seeing a lot of backsliding around democracy, in part because these institutions that were established and multi-partyism as established in a lot of these countries failed to improve the quality of life for a lot of these people. And so we're seeing backsliding. And so I was put in mind, I was remembering this as I was kind of listening to the conversation. But it also put me in mind of what I consider, or some would consider, the quasi-institutionalization of CRT itself. And that is, this was kind of put in motion and was represented, I think, in a series of workshops that ran from 1989 to about 1997 in one form. It has continued in other forms. And at that point, CRT was in part grounded in critical thought, particularly critical legal studies. It drew on earlier scholarship, particularly scholarship of Derek Bell that critiqued the civil rights movement, as well as the anti-apartheid movement. It was grounded in these kind of moments, and it was sparked by a series of events that resulted in this workshop. And I believe the workshop was initially organized by Kim Crenshaw and Neil Gatanda, who were both here this weekend, as well as Stephanie Phillips, who was my mentor and passed last year. But then CRT spurred the development of other formations, right? Not only CRS, but other formations, and you know some of those. And these formations were places where the knowledge based in the experiences of, or captured in part, of course, of the marginalized and minoritized groups, and their experience are kind of embedded in these other groups. And I'm just going to talk about one and then class crits. So I want to talk about Black crit very briefly and then talk about class crits, which were also institutionalized, became institutionalized spaces that grounded and embedded and promoted and advanced knowledge-based in experiences of, at least in part, oppression. The knowledge that grows kind of from the streets and partially captured in these spaces. So LACRIT was established in, I believe, 1995, and just last week celebrated 30 years of experience. But it brought some tensions, and I want to bring those to the fore because these tensions always exist. So people to this day question why the LACRIT formation, right, was formed. Why was LACRIT formed when you already had a CRT? That kind of question would repeat itself endlessly. And so when a group of us started Class Crits, which focuses on economic inequality, a lot of folks in LACRIT said, why do we need Class Crits? We already cover issues of class and economic inequality. And in some of our conferences, we've addressed it explicitly. So why do we need class crits? Similarly, CRT kind of would say the same thing, that when you start talking about structural racism, you're in part talking about class. You're in part talking about economic inequality and the hoarding of resources. And we too have, in a lot of ways and often, explicitly addressed some of those issues. If you don't believe me, go read Cheryl Harris's work. But at the time, economic inequality, when Class Crits was established in 2007, was growing exponentially. And nobody was really focused on that. And we were operating in an environment where law and economics was still dominant, right? The theory of law and economics of practice, and you still hear about it, was very dominant, very powerful, although it had begun to be challenged by a lot of folks. And so Class Crits really sought to kind of target and answer the law and economic analyses with this analysis about class and economic inequality. And from the beginning, unlike law and economics, it explicitly held that economic class power and inequality was inextricably connected to race and gender hierarchies, along with other social systems of unequal power and privilege. And this is a position that law and political economy, a movement and now an ecosystem that was established some 7 or 8 years after class crit, came to slowly. Nonetheless, the thought was this required some sort of focused attention. Now, both Lac Crit and CRT had a much bigger vision of life and of its mission than Class Crits. Class Crits was simply an academic association organized to provide safe space for the study of economic inequality. But Class Crit itself would ask the same question when Appeal and LPEC, Law and Political Economy, were established. Why do we need those formations when we already have this? And I think the answers to those questions are just a matter of history. So these are all formations that are institutionalized to kind of embed, generate, and advance critical thought. Critical thought, that's the basis. And they grew specifically more or less out of critical race theory, very much like CRS grew out of critical race theory and responded to a particular political moment, right? Proposition 209 and all of that sort of stuff really did push the establishment, push the emergence of CRS, and we see that across the other formations as well. So now I want to turn and talk a little bit about the Critical Legal Collective, and where am I on time? Because I'm just chit-chatting here. 2? Okay, I got a lot of ground to cover. Okay, and I got to get to the fight part. So CLC emerges, right, in 2020, in 2021, when there's a full-fledged attack on critical race theory. And let me tell you, we were slow. If it hadn't been for CRS and for the African American Policy Forum, we might not have moved. We were sitting back thinking, oh, we've heard them describe CRT. That's ridiculous. We won't dignify that with a response. And then we looked up and there were like 500 proposals, right, which sought to suppress or to regulate in some sort of way divisive concepts. And those 500 proposals, a third of them specifically sought to ban CRT. And we had been sitting around thinking, oh, that'll pass. The forum, of course, immediately kind of knew the danger of Trump's 13950 executive order and started moving really quickly, and then later brought a lot of folks from the other formations, from Lac Crit, from Class Crit, from these other places to help fight this attack on CRT. And so we all became a part of certain kind of committees, and some of those committees worked and some of them didn't. And in the process, and I don't know the full story of how this happened, but CLC was kind of born in that moment to supplement the efforts of the forum. And it was formed with a kind of different sort of angle, right? So it's informed by 12, it's informed by CRT, it's informed by Lac Crit, it's informed by this economic analysis of law, and et cetera, et cetera. And so it's born, but it's born with a goal of advocacy, which is a little bit different, right? So specifically advocacy, and but we find that law academics are not actually that great at that. We're great at persuasion, but pressure politics is not something that we're really good at, and so we brought some other things to the table. And we had kind of three sorts of themes in our formation. So we were initially focusing on trying to repel the attack against CRT. We were very much concerned about academic freedom, the ABA standards 206, diversity, 208, academic freedom, 303, cultural competency on the one hand. On the other hand, which was really different, we were really concerned about collective bargaining for the common good. So we wanted to be a part of the labor movement because unions, right, provided a counterweight to the moneyed interests that's pushing this really conservative movement. And so we went beyond traditional thinking in that we were thinking about unionism for the common good, for the public good. And so we are grounded and trying to ground ourselves in the labor movement, and that comes out. And then the third concern really had to do with wanting to advance critical thought. And so that's what CLC is about. So, last thought, this is the fight part. So, we had been growing, and we did a lot of stuff with CRS, particularly CRT Forward. We filed a couple of submissions to the UN about what's going on in the United States, and we did that with CRT Forward in the past. But now we've got two initiatives, both of which kind of focus on January and the AALS conference. And one is simply a march and a rally to allow legal academicians, the legal profession in general, and students to take a stand, to become part of a statement that says we are for justice, democracy, and the rule of law, and that we condemn the lawlessness of the current moment. And at the same time, this rally and other activities will launch our campaign, and this campaign is to make our institutions, right, fight. We want them to move from overcompliance. We want them to move from the suspension of 206. We want them to fight for themselves and fight for us. Now, they've sold people of color out already in most of the institutions, but the idea is to get them to fight, to move consciousness from one of compliance to fighting. And so we are targeting those schools and those spaces that comply with Trump's compact. And we're going to be pushing those schools and the ABA and the AALS to insist that schools and others, with their accreditation pending, right, that schools and others be true to a sense of belonging for everyone who's interested. That who becomes a lawyer, who is teaching law, is not just the vision that the Trump administration has, but is open to all of us. So that's the fight, and I now shamelessly invite you to join CLC.
Athena, just one more thing, because it's relevant to this institution, which is that we have not just partnered with CRS. CLC has partnered on a number of occasions with the UCLA Law Review, and last week, the CLC Constitutional Symposium, Teaching in a Time of Retrenchment, which features work by Margaret Montoya, Frank Valdez, myself, Mark Tizot Gonzalez, Isabel Medina, who's here, came out. So please do check that out.
Yeah, wonderful. Other comments? Okay, well, we're opening this up to the floor. So my question to you all, and you can feel free to comment and ask us questions, but our question to you all is, we've got a plan, and it's defined in some sort of ways, but we're still open to suggestions. What do you think schools, these institutions that govern legal education, and these other formations, what should they be doing in this moment? So it's one of our questions to you all. We're here to kind of pick your brains as well as try to answer your questions and comments. So I open the floor.
Blanche?
I actually have a question for Stephen. Stephen, can you elaborate more on this idea of, and I hope I'm not misstating your argument, but sort of embedding DEI principles in mission statements as a defense? If you could just elaborate on that a bit more.
So religious freedom, you're basically dangling two things before the judges. Reverse discrimination and the anti-discrimination as opposed to an anti-subordination value in front of them, and religious freedom. And you're deciding in the context of a mission-based DEI diversity mandate. You're saying you got to pick one or the other. Or does white supremacy trump religious freedom?
So for Jesuit and religious schools.
Right, for Jesuit and religious schools, though our sense is that Jesuit schools are more willing to deploy religious freedom in ways that are more consistent with anti-subordination than how schools, particularly K through 12 schools, have deployed that with regard to basically using, calling everybody a minister and saying we don't have to adhere to anti-discrimination laws because of that. So it is sort of a subset of the, of legal education, but then there's the possibility of legal education more broadly, steeping its argument in remediating what the ABA did, unless, and even if the ABA were to say, we're with you, we will disclose that we still have blood on our hands. It could, and this connects to Mario's remarks, it could be the Supreme Court applies the most favored defendant standard of Trump versus Hawaii to say, we don't care how intentional you were back then, we will find some current non-discriminatory, facially neutral thing like merit, which isn't, but they could say that, and they could say we will view what you did in line with what we find to be a non-discriminatory ground, even though you said, like Trump did, it's a Muslim ban, and then said, like, I'm not supposed to say it's a Muslim ban, but wink, wink, you know what I mean. And then have the Supreme Court say, well, let's ignore everything that was said and find some non-discriminatory national security Korematsu-like basis to do the dirty work with.
And so that was the response of Georgetown, if you remember, which is a Jesuit school. So when the Dear Colleague letter came out, Georgetown said, hey, we're Jesuits and our commitment is to X, Y, Z, and we're asserting religious freedom, and we're going to keep trying to admit as a broader group of people as we can. And they were very clear, and they were one of the first schools to try to resist and to speak openly in kind of defiance of the Dear Colleague letter. So that's one.
Yeah, the question is whether it will end up with protection for a broader swath of viewpoint discrimination, right? That's that, because not every school has the benefit of being a religious or a Jesuit school, but still have it as part of their mission, right? Or as at least part of their commitments and their values. Right. And we'll learn pretty soon whether they're allowed to.
The other, one of the Sunni schools in New York are arguing we're public institutions, as are these schools, right? We're public institutions. Our obligation is to educate everyone. Now, whether that is really sufficient to get around the ideals that the administration is trying to impose and the limits, right, that they're trying to impose, we're not sure. But they're standing their ground on DEI, on the premise that they're public institutions, and SUNY is 63 schools. That our goal and our mission is not only to pursue truth and but to educate the New York community broadly. So.
And the Georgetown letter was in response was responding to a sort of a pre-compact letter that the DOJ sent saying, we're not going to hire your students because you perform
whatever
DEI
you do.
stuff.
No, you teach DEI and you do DEI.
We think you've got DEI going on behind closed doors over there.
That's right.
And you can't do that or we won't hire your kids.
Won't hire your kids.
Your
That's
graduates.
Exactly right. Yes.
So I've been thinking about how there's different opportunities that arise. So, first, there's the conversation about power, which is, does it matter what the legal arguments are at the end of the day? Is this even a legal problem or is it a money problem? Which is, we're going to defund you, and you want to go to court, go ahead, Harvard's on its way, and then maybe the law might matter, but I suspect those who are in administration, the top of mind guys don't hear this enough.
And we don't.
But I will tell you, it is a emotionally transformative moment when you see your colleagues standing with you. Even if it doesn't change anything in the material world, it still makes a huge difference emotionally. So thank you for that. And so, what are you seeing with the impact of the letters, the sign-on letters, of the letters to administrators, of the institutionalization of CLC, even if it's not translating into immediate change? But I would be interested to hear what's working, what's not working, and how can we help as, other than joining, obviously, but you're learning along the way, right? What's working, because some folks are in every discipline are tempted to feel like, oh, we wrote all these letters, we signed on to all these letters, did it even make the difference?
Lots of stuff.
I can do a quick, I think, at least, let me see. So in the last panel, Vinay ended by saying, something he was talking about was not just a legal problem. There's more than a legal question here. That's what he said. And so, your first question reminded me of that. And of course, it's also a money problem. But I want to encourage us to think about what else is involved. So yes, it's a legal problem and a money problem, but also it's a problem involving values and our mission and our goals and our priorities and our morals and our ethics. And I think when we think about things as divorced from, the money problem is the most immediate problem. And yet, when we think about just what's immediately there, we sometimes lose track of our longer term necessities, because they may feel like, okay, well, we can try to pick up the values later, but that's not really how values work. And so I would encourage us to think about, as you've told us, what else is involved? There's the law, which all of us are talking about, and there's the money, and then there's all the other things. Steve mentioned some of those already. When you secondly brought up, is this our moment? Could we change it? That's how I felt as we were seeing the end of affirmative action before we got to the attacks. I thought, all right, great, we can get rid of educational diversity because there's more we should be doing, taking it back to some of the Michigan points you were making earlier, because the students were really pushing for a lot more. That's why we got intervention, right? Because nobody was representing those interests. So I'm a little cynical about that. It obviously, or even during COVID, I was doing a lot of research during COVID about, you remember in those that first month, people were like, we should pay teachers $1 million. All our kids were home with us and we were falling apart. And then so quickly we moved from teachers aren't doing anything and all of our students are behind and how come you're not doing better? And so I want to believe that we could use this as an opportunity, but I don't know that I'm in a place where I can feel optimistic about that.
I'll just say, the law is incredibly important. Because we have to know where the line is. Where will the courts, where will anybody draw a line and say, finally, no? And it also provides some short-term relief in certain circumstances. Erwin Chemerinsky in the Berkeley Clinic sued the Trump administration to restore UC funding, and it got an order forcing it to happen, including a couple weeks ago, UCLA got an enforcement of that, a contempt order for them to release $500 million to UCLA, right? And the notion is, while we can, and in the interim, we use every penny of that money to do the work of the university, but we also need to know at some point, and unfortunately the Supreme Court has not been particularly helpful in both its use of the shadow docket and in its decisions, unfortunately, of where we will draw a line that says you cannot hold universities hostage to your preferred ideologies. That's not what this country is about. But so I think, I remain slightly hopeful that in the end, law still matters, the rule of law still matters, and even with 6 conservatives on the Supreme Court, the line must be drawn somewhere, and if nothing else, law will do that. But I completely agree with you on DE. I wrote an article saying the diversity rationale was never the preferred thing, and that we should have stuck with race consciousness. And one of the things we can take from SFFA was what Justice Roberts says is, well, the reasons Harvard and UNC give are platitudinous, right? The connections between race diversity and positive outcomes, but we don't have any research to support. what the hell are we for if not to create the research base to show that the things we've been claiming are actually empirically true, right? And so part of this becomes our opportunity. I hate when people say, well, Gruner and Fisher weren't really overruled. I mean, overruling by any other name. He's completely undermined the use of a diversity rationale as a compelling interest. But if you can now supply the research that says there are these connections, they are meaningful, and it's more than platitudinous, can you then launch a campaign to get universities, which are notoriously risk-averse, to recommit to coming back and saying, we now have the data, and we're going to reinstitute this and let people sue us and see what happens. So my sense is, you're right in the sense of perhaps now we can use it to choose our preferred, goals, or we can also do it to create research that support the ends of what we've been saying all along.
While understanding that still gets us 5%.
Yeah.
At best.
Well, no, it's not. We're fighting so hard for minimal representation.
Yeah, and so I would say that law, I agree with Mario, law remains important, and I found that it was really important during a student protest, because I wanted students to know or have an idea of when they cross the line from protected speech and protest to civil disobedience. Right? Just wanted them to have a clue about that, because civil disobedience needs to be an informed choice. It needs to be a choice, right? I'm willing to go to jail for this. I'm moving beyond the lines, and they are not clear, but that seems to me a worthy discussion. And I agree with Mario and other views about the value of law. But this is a power game, and it is a money game. And we should not pretend, right? What we're facing is a massive degree, I think, of lawlessness while we're up here talking about law. Massive degree of lawlessness and the use of power. And what do we do about that? Backed by a great deal of money. And then money is the threat. We will take away your funding. And so how are schools supposed to react? I want to echo Mira's concerns. My thought is, if we cannot talk about that the gender discussion that these folks want to, or viewpoint that they want to impose, if we cannot say that that is an academically discredited idea, both biologically in terms of men and women, and in terms of the way we socially create our reality. And no, we're not going to just teach a lie. And if the universities are committed, are no longer committed to at least trying to teach a piece of the truth, are not willing to kind of advance their own missions about the pursuit of knowledge, then why do we need them in the first place? Right? And so we need to hold them on that. That's their mission. Same thing with the ABA. The ABA is arguing, we're under attack. We may be the federal government, appointed as however it goes, as the accrediting institution. We may lose that. And my view is, well, if you are not, your mission is supposed to be to promote excellence in legal education. If you can no longer do that, then go down fighting at least. Right? No, if you can no longer do that, you're not worth it to us. You're not going to be a benefit to us. If you're not going to protect the students, if you're not going to protect faculty, if you're not going to do any of that, then why do we need you? So your survival for your own sake is worthless to us, and why should we support you? And so my recommendation is, if you're going to go, and it does look like the ABA is going to go down fighting instead of begging and complying and clinching. At least go down fighting. We may not win, right? Derek Bell, said very early on, you don't fight just because you think you're going to win. You fight because it's the right thing to do. And so I want to echo Mayor's concern that our values, the very mission of the institutions, are being undermined by this movement, by this power grab, by this bullying. And at some point, we have to step up, and we all have to step up. And we have different risk levels. I recognize that, but, and I'm old, I'm getting ready to retire.
I got 7 years.
So
7 more.
I'm on the same track.
We have different risk levels, but that doesn't mean we can't do something
Pass the baton.
to stay. Oh, no, they're on the
Oh
list.
yeah, they're on the list. They had the same blood on their hands as the ABA. They were hand in hand. But you don't always fight in order to win. But you also fight to organize, and that's what the CLC is trying to do.
All right. We're at the end of time, but thank you all.
Thank you.